Let me begin by saying it's difficult to control a government. And I will take you to the story of the gentleman who was called Assange of US, and he was actually hunted down by Obama for having revealed information. He was a whistleblower, but the American government took that as a national security issue. So it's difficult to control a government. Why am I saying that? America is one of the most developed countries in this world. But they are primitive to the extent of how the information can be used. So Kenya is not an exception. And why? Because it's a gray area. It's difficult to control information. And one of the things that I need to begin is to ask, what happened to the principle of confidentiality? Particularly if you're talking about medical records. If you're talking about a manifest where you have passengers in a matatu or passengers on a plane, that information is confidential till an authority that has permission to get such information. So what does that mean? It means that anyone with an app, employing that app on people's phones and bringing out information that is considered confidential is infringing on those people's privacy. And if you look at the law of HIV, the disclosure of whether I'm HIV positive or not is my discretion. It is not a doctor's discretion. Neither is it my employer's discretion. So just on those principles, I think there's something just nasty about my information being on someone's phone. It is against the law. It is against the humanity of who I am. That is number one. Number two, can the government use this information for other things? Yes and no. Why? Depends with who is in charge of a particular docket. I've always said that the old constitution wasn't such a bad idea if it had the right implementers, but it had the wrong people. You can see that even the new constitution, it's a good constitution, but it has bad implementers. And therefore, the thin line whether misuse, abuse, or for particular purpose actually depends with people and institutions that have that information. If the institutions feel the information is for medical purposes, it should remain so. But you have no mechanism of ensuring that that information is archived in the right places. So I cannot give you a guarantee that that will be protected. And I'm also going to give a guarantee that your dignity will not be offended, because it is quite a thin line when you're trying to balance that right of the privacy that you need to have and the right of government to access information that I think they need to use to develop some intervention. It is quite a thin line and a gray area, which I think requires to be interrogated. We have a Data Protection Act, but what data does it speak to? That's something people may want to find out. Does data protection include some of the information that we've had about COVID-19? One, in terms of infectious diseases, the Public Health Act is quite broad. It speaks about a number of infectious diseases, leprosy, STIs, and any other disease that the government will look at and in its own context say this is an infectious disease, and therefore invite the Public Health Act and all its merits to act on it. Whether the Chinese and any other people who eat wild meat are at liberty to do so depends on the many laws that are in place. But we have laws and practice that the law could be saying don't eat meat. But what is done in practice depends on the culture and the attitude people develop around it. So in Kenya, for example, wild meat, which they call wild game meat, is illegal. Why is it illegal? Because we don't encourage poaching. And therefore there's a whole law on how Kenya Wildlife Services is supposed to act. So I cannot say with clarity that in this country you're allowed to take any game meat. Because if you look at the principle of poaching, then for you to discourage poaching, you must ban eating of game meat. And therefore, from where I sit, I think the law anticipates that we will not have wild meat because we do not support selling of trophies from wild animals. One of the reasons why game meat is banned is because of the capability or the possibility that some diseases that are for animals could actually transit into people. Because coronavirus, in its construction, is a disease for animals. It is not new. It's only at the point that it became zoonotic, that it could transfer from animals to people, that we got alarmed. The reason why those laws are put there and why game meat is banned in many places is partly because it is a source of diseases that we may not control, because our genetical codification and our white and blood cell codification is not as that of animals. We have different genome in that context. Number one, it is difficult to talk about sexual offenses, gender and sexual offenses. Difficult because they are usually very dehumanizing, and I think they bring the worst out of us. So one of the things that we need to know is, why has there been an increase? Is because people have had more time to stay together, which has not been the norm. If you go back during my old days when my father was still a teenager, my mother would stay at home in Western Kenya and my father would be in Nairobi. Maybe they'll meet to make children. I'm not sure what they used to do. But what that meant is that there was no quality time of knowing and annoying each other. So the fact that this is a phenomenon worldwide means that our relationships are so fragile in marriages. And that fragility is informed by lack of having not discussed expectations when we get in some of these unions. And while it does not justify why people must violate each other, it only speaks to what systems have not addressed, even as we purport to get married. So in terms of what can be done, it is selective, depending on where you come from and what kind of psychosocial support structures you have. This country doesn't have safe houses for women. Neither does it have for children. And therefore, if you are abused and you want to move out of that house, it's difficult for you when you don't know where to go and what to do. The government is not picking many people and putting them in cells because of the fear of the pandemic. But the Sexual Offences Act is very clear that sexual offences are serious offences and therefore do not qualify to be part of offenses that one cannot be incarcerated. So for me, if the government was serious, it will incarcerate each and every person accused of sexual offenses so that the law can take its course, irrespective of the dangers of COVID-19. Research anecdote, though, indicates that since COVID-19, courts have only registered about 200 or so cases of serious offenses. What does that mean? That many of the offenses we take people to court about are petty offenses. So the question is, if we don't have assuming it's 1,000, we only have 200. We don't have the 800 who are usually in our system. Why can't we take in these ones who are accused of sexual offenses? So for me, the government failed totally there. But then it's the same thing speaks about the innovations that the government must use. If you've been accused of sexual offense and the government feels that you are not supposed to be incarcerated in remand, they have created isolation centers. They have created quarantine centers. Why can't they put such people in such places till the situation normalizes? So the law is clear. It could be punitive, but it is clear that such people are not supposed to be part of the system because they are a threat. Because I will not take you to court. I will not go to the police if I have to come back to the same house where you parent. You are my husband. So already that's a problem. Now, when you look at what the court Senate have done in such matters is to employ the online sessions and dedicate them to sexual offenses. And say any sexual offenses, whether it is against a child, against a woman, against a man, it will be given priority. And then reduce the opportunities for giving such people police bonds. Reduce opportunity for giving those guys affordable bail. Because when you give them affordable bail, they will pay and go back home. So what they have done, they have shut women and children from accessing justice. Something else, if, for example, you had an opportunity to run away, there's curfew at 7. So where do you go? If your relative that you have gone to is in Nairobi, there's a lockdown. Where do you go? So the government needed to have thought through this and provided certain special privileges that somebody who's been accused or somebody who's facing violations can be allowed to live. At Legal Resource Foundation, there's something we call first responders. We have been saving women and children who are being abused during COVID-19 and taking them back to their homes, where they were born, back to their parents, till they arrive at a point where they think they can discuss or they can take this matter to court. Then they can do that. Why did we do that? Because we realized that there are many people in homes suffering because they have nowhere to go. Not because they have nowhere to go, the systems have locked them. So we have been going to government and getting letters to ensure that such people are transported. So we do that ourselves, give them humanitarian aid, and take them to where they feel safe. So in that context, there's a lot that can be done, both outside and within the law. But most of it is administrative. That does not require someone to invite law unless you're taking someone through the justice system. Okay, as I said, it's usually difficult for me to discuss sexual offenses because they give me the other aspect of man that is really belittling or demeaning. Where you've been sexually assaulted, there are a number of things that need to be done at the point at which that assault has happened, at the point at which that particular offense has happened. Because your body is what we call the scene of crime. If you are raped, your body is the scene of crime. And therefore that scene of crime must be treated in a particular way. And that is why they say if you are raped, you do not take a shower. Because they need to get the scene of crime in its destabilized shape. And therefore, I may not understand what happened when these offenses took place. I am talking about sexual offenses. So if anything was done to interfere with the scene of crime, even if she goes to police or to a court of law, that matter will be defeated because then evidence has been interfered with. That is one. Physical assault, including sexual assault, require that certain things must be done. One, I am sure you have heard of P3 forms and PRC forms. That those forms then are the first point at which evidence is documented that this really happened. So they will check and see, do you have bruises, do you have cuts, do you have marks, a number of things that they look if it's sexual. And that's why I'm saying that you are discouraged from doing anything else, including the clothes that you have. You're not supposed even to wash them. The reason is, on sexual offenses and any other assault, if you interfere with that particular scene, then you jeopardize the sections of law and the threshold of law that's supposed to be used to ensure that somebody is convicted. And why is because crimes in Kenya, the standard of proof is called beyond reasonable doubt. Why is it beyond reasonable doubt? That if it is found, then the punishment is maximized. That's why they say beyond reasonable doubt, that it will be wrong for you to punish somebody for something they actually did not do, because it doesn't have easier sentences. So in terms of physical, Abuse, as I've said, is you need to find out, did they ever undertake a P3 process? Did they ever go to police? And which mechanisms did they use? And so that's a story for another day. It's something that we must have a conversation to hear what did she do, and now find out what was done, how did it interfere, or how did it threaten, how then law can be applied. When it comes to issues of custody of children, maintenance, visitation, while the court is open for someone moving the court to go and say, I need this and I need that, there are a number of things that are looked at. Number one, how old are the children she's seeking to have? The law says any child, especially a girl, who is of tender age, must be with the mother. But that does not remove the court from deciding otherwise, because men are not lesser parents either. For example, if you've been missing in a child's life for circumstances that are deliberate, then the court will be right not to award you such children. But if you're missing from this children's life for circumstances that you were forced into, then the court will also have to understand. But before the court makes some of those decisions, when you go to court about a child's matter, they are likely to refer you to alternative mechanisms. Why? Because where children are, relationships are more important. It is only when those relationships don't make any meaning that the court decides, let us use our own discretion to make a decision. But the court will look at a number of things. It will look at the relationship you have with those children. It will look at the view of the people living with those children. It will look at the view of the children themselves, especially if they are children who can express themselves. And putting all these things together, it also look at where you've been residing, what efforts you have been making. So if she's making efforts and we have records to that effect, that then creates good ground for her to make a petition in court that I need these children for a number, depending on reason A, B, C, D. And we have sections of law that support that. So it may be difficult to give you a straight answer because I do not have the priority of whatever it is that she has gone through. But the law is on the side of people who hurt. And it also has limitations. For how long this has happened, for how long did the first incident happen, the law has limitations. That it could be maybe 7 years. After 7 years, then it becomes a difficult matter to address. So I may not be very effective in responding to exactly what she needs to do, but I need her to know that the law is on her side. If she can put all the things she has gone through and provide evidence. The only problem that she may find is where we have sexual offenses, particularly spousal rape. Spousal rape is between you, my word against your word. You are my wife, so it is my word against yours. So if I am raped tonight, I need to walk to a police station and I need to say, this is my husband. My husband has raped me. What do I show that I was raped? Maybe I have a torn night dress, you know. Maybe my hair is has been plucked off, you know. And then that starts making people believe that your spouse actually forced himself on you. So spousal rape is common. It's difficult to litigate, but it's because people do not understand what to look for. If, for example, you struggled in the house, he beat you up, he pushed you on the wall, those are the things. And if that has happened, and you have his fluids in you, because he's your husband, most likely not use a condom. Or if you use a condom, you can pick it from the house. If you go to a police station with those things and they are recorded, and you've taken all the precautions, you haven't showered, you haven't done what? Believe you me, that's a matter that merits the court to listen.